Okay, so essentially the law says you must not use your mobile phone whilst driving, or more specifically it says you must not use a device which is performing an interactive communication function. And by interactive communication function, the law means making or receiving telephone calls or making or receiving texts. Potential penalties are you could be disqualified. In a worst case scenario, more likely you will receive an endorsement of 6 penalty points and a fine. Okay, so essentially the position is you can use your phone provided you're using Bluetooth in your car and you do not touch your phone. So most of us have got Bluetooth in our car now, and as long as we use the buttons, whether it's on the steering wheel or the dash or the center console or wherever it is, as long as we touch the buttons in the car and don't touch the phone, then you are keeping yourself within the law. But as soon as you touch the phone, then you are deemed to be using the phone and thereby committing the offence. If you're using it hands-free and you only use it hands-free, no, but there is a danger because hands-free isn't always perfect, hands-free may be unreliable, and some people may spend 10 minutes on a call and then finish the call by pressing the button on the phone. If they do that, they've committed the offence. Hands-free must remain completely hands-free. Okay, so now we come on to the crux of the current difficulty. When the law was framed, it dealt with the then new menace of people using their phones at the wheel. And at that time, all you could do with a mobile phone is make or receive a call, make or receive text, or take a really lousy photograph. The invention of the smartphone changed everything. Suddenly, we all had a really powerful and versatile computer on us. We could surf the net, we could play games, we could play music, we could take high quality video, we had sat-nav function and all the rest of it. Actually, making a call was a very, very small part of what a smartphone is. The law has completely failed to keep up with these developments and has remained silent on them. There has been a helpful case where a person who took a photograph whilst driving was prosecuted for using a mobile phone. They pleaded not guilty, and quite properly the court acquitted them and found them not guilty on the basis that taking a photograph was not an interactive communication function, which of course it isn't, but it begs the question as to whether other things might be. It could be argued that using a sat-nav is in fact making use of an interactive communication function because you're communicating with satellites that are circling the Earth. If that is the case, then every single taxi driver that I've ever ridden with in the last 5 years will be committing this offence about 10 times a day, every single day, because they all use their mobile phones as a sat-nav. They need to clarify all of them. There are 3 principal areas they need to concentrate on. Firstly, they need to define exactly what an interactive communication function actually is. Is it texting or phoning, or does it include other things? Secondly, they need to make a judgment as to whether they are going to include other functions within the list of prohibitions. Are we going to continue to use the sat-nav, for example, or not? And if not, why not, and in what circumstances? And thirdly, they should define more closely exactly what using actually means, so that it's quite clear to everybody, those driving using a phone, and indeed the police officers enforcing the law, what actually constitutes an offence and what does not, because at the moment that is very far from clear.